Good afternoon, everyone, or I should say good morning. I'm so used to saying good afternoon for our programs. We've actually shifted in recent months to morning programs. So good morning, everyone. My name is John Cornwell. I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to serve as coordinator for today's program, which focuses on providing you with the information you need to navigate what we're terming the new age of reasonable, especially when it comes to accommodating FMLA and ADA requests by your employees. The pandemic has fundamentally changed a lot of things in the workplace, as we all know, especially employees working hybrid schedules or even 100% remotely. So joining us today to help make sense of all of this are two members of our Labor and Employment Practice Group, Laura Dinan from our office in Petoskey, Michigan, and Christina Corral from our Columbus, Ohio office. So before we get started, I always have the job of pointing out a few things to folks that attend our programs. And we want to talk a little bit about the backgrounds of our presenters and also about our firm. So for those who may not know us very well, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 140 attorneys. Our offices are in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. We have a large employment law practice consisting of approximately 20 attorneys who work in the areas of traditional labor law, human resources consulting, investigations, and employment litigation. And I do want to mention that today's webinar has been approved for 1.25 general recertification credit hours through the HR Certification Institute and for 1.25 professional development credits through SHRM. Following today's program, we'll send you a certificate of completion reflecting the credit. If you don't need the CE credit, simply discard the certificate. And so at this time, I'd like to introduce our presenters. And as I mentioned, we have Laura Dinan and Christina Corral with us today. Start with Laura. Laura has over 30 years of experience advising employers on all types of workplace-related issues. She's built a successful practice representing public and private sector employees of all sizes throughout northern Michigan. Laura's expertise includes consulting on employment law issues, administrative hearings, traditional labor, and even litigation. She's a current board member and a past president and past secretary of the board of directors of the Northern Michigan Society of Human Resource Directors. Christina Corral is the managing partner of Plunkett Cooney's Columbus, Ohio office, and she serves as co-leader of the firm's Labor and Employment Law Practice Group. Christina has extensive litigation and trial experience defending employment cases in state and federal courts. She represents numerous employers and has the distinction of serving as special counsel to the Ohio Attorney General for employment matters involving several academic institutions, including the Ohio State University. So now for a couple quick housekeeping notes, and we will get underway, I promise. For the Q&A portion of our webinar, we're going to use our questions widget on your navigation or your dashboard. So please find that questions widget at this time. And we always encourage you to type in your questions as we go along so that we can get right to them at the end of our program. And one of the things I always mention regarding questions, and this is one of those topics when I know it's very fact specific, but we do want you to use some judgment about how much you divulge in your questions. We don't want to have any corporation names or anything like that pop up in the questions. So please do what you can to make those a bit generic for the audience. And finally, I want to mention that today's session is being recorded, and that recording will be available on the event page of our website, which is located at plunkettcooney.com. Feel free to share a link to that page or direct your colleagues there, and they'll be able to view the recording 24/7 at their convenience. So at this point, I think I'm done talking, and I want to turn it over to Laura and Christina. And Laura, I believe you are leading off today's presentation.
Yeah, thanks, John. Christina and I are glad that you are all attending today. We know this is a really hot outline for you to take away because we know that we have a lot of information and it might be hard to absorb some of it in just this webinar. And because we have a lot of information, it is going to move along. We're going to try to move it along pretty quickly so we can get to some of your questions at the end. So with that, we'll get moving. So everybody is pretty aware, if they're on this call, that when it comes to complying with the law, both the ADA and FMLA are two of the most difficult laws to deal with, very fact specific. This webinar is going to focus on what are reasonable accommodations under the ADA, with a little discussion of Michigan's Persons with Disabilities Civil Rights Act, but because it's interpreted using primarily ADA cases, we really are focusing on the ADA. And we're trying to focus on issues related to COVID-19, which obviously involves remote work, and the interplay of these acts with FMLA. So like other civil rights laws, the ADA and the Michigan Persons with Disabilities Civil Rights Act prohibit discrimination or harassment based on a protected status, specifically disabilities, whether they're actual, perceived, or a person's history of disability, or because the person associates with someone with disabilities, i.e. a spouse, a child that requires their attention. So both the ADA and the Michigan Act require more of employers. They prohibit discrimination and harassment, but they require employers to provide reasonable accommodations. Again, primary focus today is ADA, and if you're a small employer, especially, you should become familiar with the Michigan Act, because that's where there is a difference between the ADA and the Michigan law. Michigan doesn't put as many requirements on an employer, a small employer, as far as what they have to provide in accommodations. Next slide, please, John. Under the Michigan law, it applies to an employer of one or more employees. So basically, everyone is covered by Michigan law, and there can be personal liability for the decision maker if they violate the Michigan law. Under the ADA, it only applies to employers that are engaged in industry affecting commerce, having 15 or more employees for each working day in each of 20 or more calendar weeks in the current or preceding calendar year, and there's no individual liability for decision makers. Next slide, please, John. Under Michigan law, a claim can be brought in circuit court within 3 years of the alleged violation, but as an employer, you can shorten that statute of limitations period down to as little as 6 months, and you have to do that in writing with specific language. So if you don't have that in your handbook right now, you might want to talk to your employment lawyer and get that added. In Michigan, ADA claims have to be initiated by bringing a charge with the EEOC within 300 days of the alleged violation. So the lawsuit doesn't have to be brought within 300 days, but if they have to file a claim with the EEOC within 300 days of the alleged violation, and it can take a really long time from that point on to get the case out of the EEOC and into the courts. After the administrative process is completed at the EEOC or the Michigan Department of Civil Rights, the parties get 90 days to initiate a lawsuit. And it's not clear if that 90-day period can be shortened. I would assume for purposes of planning, it can't be. Next slide, please, John. Under Michigan law, the aggrieved party can get compensatory damages and attorney fees, but they can't get punitive damages. Michigan law doesn't allow for punitive damages. And if they do receive wage loss damages, that would be reduced if they got any work comp benefits from the same employer for the same disability. So the ADA allows for compensatory damages also, but they can get punitive damages, and there are certain caps on that based on the size of the employer. and they can also get attorney fees. And one of the things about attorney fees in these types of cases is they could recover only $1, and that would make them eligible to get all of their attorney fees back from the other side. So it's a very dangerous factor in determining damages. Attorney fees can and often are in excess of the actual damage award to the plaintiff. Michigan law requires an applicant or an employee, because remember, these laws protect applicants for jobs as well as your actual employees. So under Michigan law, the applicant or employee with the disability is supposed to request an accommodation in writing within 182 days of the day he or she knew or should have known that the accommodation was needed, if the employer tells them about the 182-day request or requirement. So as an employer, you should put this 182-day requirement in your job applications and in your handbook. Under the ADA, a person doesn't even need to request accommodation in writing. They can make the request at any time by the employee or another person acting on behalf of an employee. And that comes up when someone is hospitalized frequently, and they aren't able to call the employer and ask for an accommodation, or it also comes up when a person has a mental health issue and maybe a family member calls and explains to the employer that some accommodations are necessary. You have to begin the interactive process if that happens, because the ADA is very broad in how you can make a request for accommodation. Next slide, please. Both the ADA and the Michigan law only require an employer to provide accommodations if they don't cause an undue hardship to the employer. And we're going to talk about undue hardship later. The types of accommodations under Michigan law are specified in the statute, and the Michigan law ties undue hardship with the actual dollar figure based on the cost and the size of the employer. The ADA is much broader. It's only limited by the concept of undue hardship, and the employer has to prove it's an undue hardship. The cost and the size of the employer will factor in, but it's quite different from Michigan law. Next slide, thanks. The burden of proof for failure to accommodate is specified. Under Michigan law, the plaintiff or the employee has to prove by a preponderance of evidence that the accommodation would not cause an undue hardship on the employer. How much the employer must spend on accommodations is determined by the number of employees. So under Michigan law, the plaintiff has to prove that it's not an undue hardship. Next slide, please, John. And the Michigan statute actually lists types of accommodations that have to be provided. So if you're a Michigan employer, I think most of the provisions that would be different from the ADA apply to employers of 15 or less, and it's broken up by under 4 employees and maybe 10 and maybe 15. I haven't looked at it in a while, but if you're one of those employers, you might want to look at the Michigan statute and familiarize yourself with it, especially if you do have employees that need accommodations or may need accommodations. So under Michigan law, accommodations that may be required could include buying them devices or equipment, hiring readers or interpreters, restructuring jobs, or altering schedules, but it depends on the size of the employer. And next, Christina's going to touch on FMLA.
Good morning, everyone. Thank you for joining us this morning. As Laura said, we are going to move through this information fairly quickly, especially the FMLA information. And the reason for that is we all need to get back to our full-time job, which is watching the Johnny Depp Amber Heard trial. So we're going to blast through this pretty quickly. As we all know, as human resources professionals, the FMLA and the ADA fit hand in glove. They go where one ends, the other picks up, and we know that we have a lot of issues in the workplace having to do with the interaction between FMLA leave and ADA leave. So just a very quick FMLA overview. We all know that there are certain categories of things that happen in your lives that will qualify you for FMLA leave: the birth of a child, the placement of a child in an adopted child, an employee's own serious health condition, and also the serious health condition of certain members of an employee's family that are defined within the statute. FMLA was amended to also include military type leave. I will tell you that military leave is pretty detailed and fact specific. So we sort of have a highlight here. You know, there are categories for emergencies for family members of those in the military. And then there's a leave available for up to 26 weeks. I mean, look how different this is from normal FMLA leave to care for seriously ill or wounded military family members. Covered employers under the FMLA. Remember, FMLA is a federal statute. Employers engaged in commerce with a minimum of 50 employees. You public employers, though, boy, you're covered no matter how many employees you have. And we all know, at least those who have been involved in these issues, that to get to that 50 employee threshold, it takes in employees that are employed, say, at branch locations within a 75-mile radius. Employees are eligible for taking FMLA leave after having worked for 12 months and 1,250 hours, and the 12 months do not have to be consecutive. And so what do you have to do to provide FMLA benefits for your employees? I think the general public mostly misunderstands what FMLA is. Those of us on this call, our professional HR folks, know that this is really a job holding statute. This is not a benefits statute. This is not a paid leave statute. This is a job holding statute. So you have to do two things. You have to maintain the employee's health insurance, and then when they return from leave, you have to return that employee to his or her original job or an equivalent job with the same pay and other terms of employment. One of the big issues that we see as human resources professionals in the FMLA realm is the notice requirement, and we're going to get into some of this later, but the reality is that you as human resources professionals have to keep your eyes and ears open to requests for leave or even information that you get from your employees that would indicate that they would qualify for FMLA leave. And they do not, there are cases out there that talk about the fact that employees do not have to say the words FMLA in their request. Now, I know many of you have processes and procedures in place that avoid many of these pitfalls. But for those of you that don't, there have been courts that have held that if you're on notice of a serious health condition of your employees or of their family members, you can be deemed to have known that you should have been granting FMLA leave, even if it wasn't formally asked for by your employee. So here are the requirements for your employees. If foreseeable, they need to give at least 30 days notice. I think maybe that's happened one time in my career. Everybody else gives about 3 or 4 days, maybe a week. If unforeseeable, as soon as practicable, and the notice can be verbal, right? They are not, I know everybody has policies and procedures in place, but verbal notice is sufficient. The other thing that we all know having to do with FMLA leaves is employers can require their employees to follow specific established policies and procedures when it comes to requesting FMLA leave. You can require that the notice be in writing. You can require that the notice be provided to specific persons within your organization, and you can require your employees to follow call-in procedures. And then, yes, employers do have a right or two under the FMLA, not many, but some. You have the obligation and right to designate certain types of leave as paid or unpaid leave. You can, in fact, designate leave as reducing your employees' FMLA leave banks, even if they don't specifically request for FMLA leave. And then, again, even if your employee asks that it not be designated as FMLA leave, you can designate it as such. You must do so, though, however, within 5 business days of the request. Once you've decided on the leave, whether you are deeming it FMLA leave that the employee didn't ask for, or whether the employee is asking for FMLA leave that you are now approving, you have to provide to your employees certain information in your response to their request. You must say whether they're eligible or not and why. You need to tell them, and many policies have this already contained within the policy, requirements for medical certification and the consequences for failure to provide medical certification, any right or requirement that you use paid leave that the employees have accrued over time. You may require your employees to pay their health insurance premiums. You have the right to maintain health insurance and return to the same or equivalent job. That's what needs to be in your notice. And also, you need to address key employee status if applicable. We're not going to get much into key employee status because it's such a fact-specific issue, but those are the things you need to do in order to make sure that you are handling your FMLA requests appropriately. And now we're back to Laura.
Thanks, sorry, couldn't find the mute button. So if an employee's been off on FMLA for their own serious health condition and they exhaust their available FMLA leave time, which happens fairly frequently, at least maybe I should say we get those questions fairly frequently. You call them or send them notice, here's your expiration date. We expect you back at work on such and such a date at such and such a time. And they aren't able to return to work. At that point, under FMLA, technically they lose their job protection, but no. If their serious health condition qualifies as a disability, then you have to consider the ADA and the reasonable accommodation process. So you've got an employee can't come back when FMLA expires. So at this point, you as an employer have an obligation to engage in the interactive process with the employee to see if a reasonable accommodation is necessary and to see if there's one that even exists that could allow the person to do their job. We want to caution you, you cannot begin the interactive process until FMLA leave has expired. So I frequently hear, well, I gave them 2 weeks notice of FMLA expiring and they told me that their doctor's not going to let them come back to work. The answer to the employee at that point in time is, okay, call me on the date that you're supposed to report back to work and we'll figure out what the next step is. Don't start sending medical inquiries. Don't deal with them until their FMLA expires because you're not supposed to interfere with their FMLA leave. Under the ADA, a person has a disability if they have a physical or mental impairment that substantially limits a major life activity, which can be work, a record of a substantially limiting impairment, and people who are regarded as having a substantially limiting impairment. Under the ADA amendments quite a few years back, basically any physical or mental condition is a disability. That's your starting point. So we basically skip over that and go to the limitations. So the EEOC notes that limitations from COVID do not necessarily have to last any particular length of time to be substantially limiting. So this is a little new. We used to see broken legs or things that had a finite period of time and it was considered too short to be an actual disability. The EEOC is saying COVID, if the restrictions are big enough, might be substantially limiting to qualify as a disability. So this is new. Restrictions that last several months can qualify. And in addition, EEOC is looking at the treatments, and some of the mitigating measures used for COVID are causing negative side effects in some people, and those are substantially limiting major life activities or bodily functions. So this whole long haul COVID, but even not necessarily long haul, but a serious bout of COVID that leaves people with diminished capacity to work may very well be a disability under the ADA in a new way than we've seen before. So claims based on impairments resulting from COVID-19 and its after effects are starting to show up. And again, it's not limited to long COVID. And employees are bringing claims arising from the mitigating measures or treatments like we just talked about in the last slide. Some of these have negative side effects that substantially limit individuals' major life activities or bodily functions. And employers have to look at every case to determine whether the condition is a disability on a case-by-case basis. It's very, very fact-driven. And, even the medical community is having a hard time assessing these situations at this point in time. And so it puts you in a hard spot. There's no right answer, but be aware that you have to be a little broader or a lot broader in your interpretation of disability when it comes to COVID issues. So we're seeing a rise in claims from employees that had pre-existing conditions that they were managing well and they didn't require any kind of accommodation. But now that underlying condition has been exacerbated or turned into another serious illness or complication due to COVID, about with COVID, and previously it was not substantially limiting, so they didn't need any kind of accommodation, and now that impairment could be substantially limiting, and you've got these employees coming forward, not necessarily for an accommodation for the actual COVID impairment, but an impairment that was exacerbated by COVID. So that's another side effect that you have to be aware of. Definitely, employers are seeing an increase in claims based on psychological and emotional impairments. Mental health is all over the news, and I'm sure that everybody to some extent has had to deal with this, maybe not rising to the level of accommodation, but you've all got employees that are just really struggling due to a wide array of issues with COVID, even right down to just the isolation, being home alone and working from home for so long. The EEOC has put out there that employees with certain pre-existing mental health conditions might have more difficulty handling the disruption to daily life that has been caused by COVID, and these are going to be disabilities that need accommodation by the employer. Working remotely, social isolation has really invaded the workforce. I mean, society in general, but really impacting a lot of different sectors of the economy and the workforce. So be aware that you are going to have to address the need or potential need for accommodations for those types of disabilities. So an employer's obligations under the ADA are much broader than under Michigan law. The key to determining an employer's obligation to accommodate is first determining the essential functions of the job. It's a huge deal that you must have good, extensive detailed job descriptions. Don't wait for someone to ask for an accommodation. Create them now if you don't already have them, and make sure that you identify the essential functions. If a person is a receptionist and needs to be at the front desk in your facility every day, then attendance is an essential job function. If it's a person that works in a call center and can answer phones from anywhere, then attendance may not be, well, I guess that's the wrong word, but in-person attendance may not be an essential function of the job. So it's got to be job specific, but make sure you have those good job descriptions so that if someone asks for an accommodation, you need to look and see what the essential functions are and if the accommodation goes to those essential functions. And it's a good idea to ask on your job application if you can perform, if the employee can or applicant can perform the essential functions of the position with or without a reasonable accommodation. If they answer yes, you can't ask any more questions at that point. But if they answer no, then you don't have to take it any farther. So under the ADA, essential function means fundamental job duties, not the marginal tasks. It may be essential because it's the reason the job exists, or there are a limited number of employees who can actually perform that function, or it's highly specialized and the person was hired because of their expertise. Next slide, please. When you're determining essential functions, it's the employer's call to determine if something's an essential function. The employee can tell you that, you know, this really isn't an important part of my job. It's not an essential function. I don't need to do it, but it's not their call. It's your call, whether it's an essential function of that particular job. And when you are assessing the need for accommodation and looking at essential functions, it's very, very fact specific as to what that person actually does. So again, you need a written job description ahead of time. You look at whether, how much time that particular function takes to perform. So if it's a 5-minute, I don't know, load the dishwasher or something for someone in an office job, that's probably not an essential function. But there could be essential functions that are key to the job that are a short period of time, but that's one factor. What would happen if that function is not performed? What does someone else have to pick it up because it's so important, or is it just something that could go by the wayside and nobody would really notice? You look at collective bargaining agreements when you're assessing essential functions of a job, and you look at the work experience of the current employee and the people who held that job before to see what they did. And if everybody's done the same duties, then it's probably an essential function of that job. So the kinds of accommodations required under the ADA aren't limited like they are under Michigan law. A reasonable accommodation under the ADA may be any change in the work environment or how the work is done that will help a disabled person apply for the job, perform the essential functions of the job, or enjoy all the benefits and privileges of employment. So as employers, as employees work through and past COVID, the reasonableness of an accommodation standard is a moving target. It's changing, and you need to keep up with the times. And the EEOC has been updating their guidance on a I don't know if I'll say fairly regularly, but every several months, they do put something else out there. And I know that Jan is trying to keep up. So we're trying to fill you in on what we're aware of now, but this changes by the day, honestly. So be aware that accommodation requests are a whole new ball game, and things you wouldn't have dreamed of are coming into play when people make requests these days. Next slide, please. So for years, the EEOC position was that the ADA did not require employers to offer remote work options. They only required that if you did allow people to work remotely, then you had to allow employees with disabilities an equal opportunity to participate in your remote work program, but you didn't have to offer remote work. So employers generally were successful in the past in convincing courts that employees needed to come to work and it was an essential function of most jobs, and they didn't need to offer remote work as an accommodation, and the courts bought it. I don't think that's going to be the case going forward, and there already are some cases working their way through the system that Christine is going to talk about a little later. But as everybody here probably knows, during the pandemic, almost, well, I don't even know what the percentage is, but many businesses were able to continue operating by allowing their employees to work remotely while the various states were under lockdown orders. And so it worked, and the businesses kept in business and kept their employees, and the work got done. You know, certain jobs it wasn't as efficient, but many jobs were as efficient. And so going forward, it's going to be pretty hard for a lot of employers to deny someone remote work as an accommodation. It can still happen, but it's going to be a lot harder. So employers need to be prepared to base your decision to deny a request for remote work on a fact-specific examination of the job's essential functions. So you can do it. You're going to be able to do it with certain employees, but it's get your facts lined up and do an actual analysis in writing. You don't give it to the employee, but you're going to need it to back up your decision as to why this job's essential functions need to be done in the workplace and can't be done remotely. And then you have the added problem: if you accommodate an employee by allowing them to work remotely, you need to consciously keep them engaged with the people who are actually coming into work, because you don't want some kind of retaliation claim for, you know, saying, oh, fine, you can work remotely, but then you ignored me, like I wasn't part of the team because I worked remotely. So another fun thing for you to consider. So there's an EEO guidance out there that was updated, again, March of 22, so pretty recently, and it's what you should know about COVID-19 and the ADA and the Rehab Act and the other equal opportunity laws. And we pulled a couple questions out of here that seemed relevant to the topic. So EEOC put the question out: when an employer reopens the workplace and recalls employees to the work site, does the employer automatically have to grant telework as a reasonable accommodation? Again, no, you don't. But if the employee can show that there's a, well, first of all, the employee has to show that there's a disability-related limitation that necessitates an accommodation. And if there isn't one, you don't have to provide telework, because you don't have to provide any accommodation. But if there is a disability and you can address the need with another form of reasonable accommodation in the workplace, then you can choose to deny remote work and offer a different reasonable accommodation. So for instance, this came up, I think, frequently with people with medical conditions that were worried about being exposed to COVID in the workplace, and you could put them in an office where they were isolated from other people, or, you know, build plexiglass workstations, things like that. But that would be an alternative to remote working to protect people from germs. We can't even possibly begin to anticipate all the scenarios, but that would be one. So to the extent employers permit telework to employees because of COVID and are choosing to excuse employees from performing one or more essential functions, then a request after the workplace reopens to continue telework as a reasonable accommodation does not have to be granted if you would still have to continue to excuse employees from performing an essential function. So you made special rules for everybody while they were home doing remote work and excuse them from performing some essential functions. Once you've called everyone back to work, someone wants an accommodation and wants to continue telework or remote working without having to perform the essential functions that were excused, now you can require them to come to work if they can only do essential functions from work. I mean, you have to consider the whole accommodation issue, but the ADA historically and the EEOC is telling us continues the to not, I get this is a double negative, not require an employer to eliminate an essential function as an accommodation for an individual with a disability. The purpose of the ADA is to assist employees with accommodations that allow them to perform essential functions, not to eliminate the essential functions they can't perform. So the fact that an employer temporarily excused performing essential functions when they were locked down during COVID doesn't mean that that job description permanently changed. When you went back to full capacity, brought people into work, that essential functions stayed with that job, and it's a consideration when you're working out accommodations or assessing whether there are accommodations that are reasonable. So employers also don't have an obligation under the ADA to refrain from restoring all of the employee's essential duties at the time it chooses to bring people back. I guess we just talked about that, sorry. And then when you evaluate any requests for continued or new accommodations, you use the usual ADA rules, even though there might be new scenarios due to COVID regarding the disabilities and the need for accommodation. You're still using the same prior rules, and you don't have to loosen up how you assess accommodations and the impact on the workplace. And again, these are extremely fact-specific determinations. I've never had the same request twice, because even if it's the same disability, same request, different workplace, different job, it's very, very fact specific, and you have to go through the whole analysis each time. And with that, I'm going to turn it over to Christina to talk about some of the current cases we're seeing.
Well, so as you might imagine, some of these cases have started to wind their way through the courts. I'm going to move through these extremely quickly because we are getting a little behind on time, and I want to try to keep us on our time commitment. We have very detailed information in here about these cases, but this first case we included because all of you know that when everybody was required to come back to work, you had a whole bunch of people saying, I don't want to come back to work. And so what we've seen over the last year with accommodation requests is that employees want to tell you what their accommodation is going to be. And this is a very good case that illustrates that it's not up to the employee to determine what his or her accommodation is. The accommodation needs to be reasonable, and that is what is decided on by the employer. So you can see here in this school teacher case that this teacher wanted to work only remotely from her home. And the employer said, well, we'll allow some of that, but we've also got provisions set up so that you can come into the office and be away from other folks. And the court held that that was a reasonable accommodation. So I'm sure you're all getting these types of requests that your employers are telling you what they want to have for their accommodation. Here we go back to what we talked about a little bit earlier. This is a case where someone requested an accommodation without formally requesting an accommodation, right? And the employer said, well, you didn't formally request it. And the court said, well, wait 1 second. You don't have to formally request it. You can go on to the next slide. Just because the employee didn't use specific words like request or accommodation, you as an employer are charged with the task of interpreting what the request is from your employees and deciding whether that request is one that would qualify either as an ADA request or an FMLA request. You can move on to the next one, John. And so the court found in favor of the plaintiff in this case. In the next case, this is another COVID-19 case, and the employee wanted to stay at home and self-quarantine due to concerns about getting COVID-19. The court looked at what his potential disability would be that would stand as the basis for his request to stay home and self-quarantine. He was a smoker of 30 years, a pack a day. This employer was exempt from Governor Whitmer's stay-at-home order as an essential business. And so the court actually in this case ended up ruling against the employee and saying that he has not met his burden, and you can go on to the next slide, to demonstrate that it was reasonable and required that he stay at home. And this is what, and I want to point to this case on this slide. This is what I must have had a dozen of these very doctor's notes from employees which say something like this. It's recommended that the employee work from home if possible, right? Well, what in the heck does that mean, if possible? I guess it would always be possible if you made it possible. And so what I have told my employers so far is that working from home, if possible, is not a proper medical documentation that would justify granting a request for an accommodation. And that was part of what the court relied on in this case to rule against the employee and find that he wasn't entitled to this 3 weeks or 3 months of stay-at-home self-quarantine. You got to be very careful. And again, this is very, very, very fact-specific. But I know we are getting a lot of requests in from doctors that the medical documentation that's being turned in does not say that my patient has a disability that requires the following accommodation. They're saying things like, if possible. So just keep your eyes open for those types of issues. And as I said, if you go on to the next slide, you'll see that the court ruled against this employee and found that he was not entitled to the accommodation that he requested. So on to, now that we've talked about some cases, we're talking about some accommodation examples. You know, this is as fact specific as you have different employees, right? But one of the things that really we talk about more than anything in the accommodation area is time away from work, right? So Laura talked about some of these things earlier, you know, modifications in your workstation, your work schedules, those types of things. These are for the purpose of assisting the employee in doing their job, right? This isn't just, I want to do something a certain way because that's the way I want to do it. This actually has to be assisting the employee in completing their job. You can go on to the next slide. Again, we were talking about this. This is not, the employer do not need to provide an accommodation that is the most convenient or not job related. You do not need to structure a job to fit someone's abilities. This is what is, you're expected to accommodate a disability by coming up with a reasonable solution that works the best to accommodate both the employee and the employer. And again, remember, this isn't, and Laura, am I going into your slides? Did I totally just mess that whole thing up?
Yeah, it's fine.
We're going to turn, I'm going to turn this back over to Laura just for a few more slides. Sorry about that.
No problem. Yeah, the whole interactive process is designed to meet both the employee and the employer's needs. And so oftentimes more than one accommodation is discussed, and you gather all the information, and there's a broad range of accommodations that are out there for almost, I mean, there's hundreds of disabilities, and there are lists of accommodations, but when it comes down to it, it's the employer's decision, as Christina said, and your accommodation needs to be designed to let the person do the job. And so one of the really ironic things about that is that the EEOC considers leave or leaves of absence to be a reasonable accommodation. And it really is mind-boggling because it takes them away from the job. But I think that it got started that way because employees were given extra leave so they could heal and go back to doing the job. But it's really kind of ironic that leave is allowed to help you perform the essential functions of the job. Next slide, John. So the employer is not expected to accommodate a disability that they are not aware of, and it's generally the employee's obligation to ask. But if you can see an employee is struggling, or you're aware that they have a disability, or where the individual might be mentally challenged and they don't know to ask for accommodation, you have an obligation to start the conversation and start the interactive process. The EEOC suggests the following flexible interactive process problem-solving approach that involves the employer and the employee, but this suggests is in quotes for a reason. It is not a suggestion. You have to do it. And the first person to drop the ball in the interactive process is the one who's going to lose if there is a claim filed in court. So if the employee doesn't cooperate, they're going to lose. If you drop the ball and don't cooperate, you're going to lose. That's plain and simple. So the interactive process means that the employee somehow conveys that they need an accommodation to be able to perform the essential functions. Through the process, you analyze the job, the purpose of the job, and the essential functions of the job. The employer consults with the employee to determine what their job-related limitations are and how an accommodation can help them overcome those limitations. So with every employee, you have to identify the potential accommodations and assess the effectiveness of each accommodation with relation to performing the essential functions. You consider the employee's preference and you select and implement the most appropriate accommodation for both the employee and the employer. And if there isn't one that satisfies both of you, the employer's choice wins. Keep in mind, state law, Michigan protects employees who require leave for COVID-related reasons in addition to the disability laws. That's a separate law. And if you have people that require leave for COVID, even though they've long blasted through all their accrued PTO and they don't have something rising to the level of a disability, but they keep getting COVID. I have an employer who has people who've had it like 4 times, and it's just because they're, they won't get vaccinated and they aren't careful and it's in the community. and they want to take action against them, you can't, because they're protected from retaliation for requiring leave for COVID. If the individual provides their own accommodation, say they purchase their own software, or they purchase their own bigger monitor for their computer, but then they take it home, at that point, the employer would have to step in and continue providing some sort of accommodation. Just because the individual provides their own accommodation to start, it doesn't relieve you of a duty to supply an accommodation if they ask for it. And where it's obvious, the employer is expected to just provide an accommodation without going through the interactive process. I've seen that a couple times, but it's normally you're going to go through the interactive process. Usually when it's just it's a situation where you just provide it, is a situation where, for instance, somebody needs a mat to stand on. It's pretty cheap. You can tell the person has back problems and you just get it. But most of the time you're going to use the interactive process. And if you are not familiar with JAN, the Job Accommodation Network, familiarize yourself with it immediately. It's an independent agency. It's not part of the EEOC, but the first question the EEOC will ask if you get a discrimination claim based on denial of an accommodation is, did you consult JAN? It's this vast website that lists hundreds, if not thousands, of potential accommodations matched with the disability, like everything from diabetes to ADHD, everything. And it's very useful. You can go on the website and find a lot of information, and you can also call these people. It's a very, very good resource. And next slide, John. An employer, this is an interesting one, and it's touchy, but it comes up. As an employer, you can't require an employee to accept an accommodation where it's not requested or wanted. This comes into effect, I see it frequently with an employer wanting to put someone on leave and they don't want to go on leave. And if they can still do their job, you can't make them go on leave. If an accommodation is refused, however, and the employee can't perform the essential functions of their job, then they're not qualified for the job and you can terminate them. Obviously, that's a very broad statement, and don't do it without talking to your attorney, but they can't just refuse accommodation and not do the job. And no accommodation is required where the employee is regarded as disabled, but they're actually not disabled. All right, Christina, back to you.
Okay, medical inquiries. We're going to blast through this pretty quickly. As you're all aware, you can make a medical inquiry to determine whether your employee is eligible for ADA leave or not. If you look at the next slide, we can see what you can ask. It's a pretty limited scope of what you're asking about for the employee to provide medical documentation, or in the event that the employer itself is getting a second opinion. We know that it applies to major bodily functions. I'm sorry, our sirens are going off here for our for our tornado test. So also with the medical inquiry, if you go to the next slide, you can ask how the accommodation would assist the person in either applying for a job, performing the essential functions of the job, or enjoying equal benefits and privileges of his or her job. Those are all fair medical inquiries. You know, each letter should be tailored specifically to the circumstances. I know everybody has letters that they use for these very situations. Just make sure you're tailoring each of your letters to the specific circumstance involving the employee. The next issue is probably one of the biggest issues that we deal with the ADA, which is undue hardship. It's the employer's burden to prove an accommodation is an undue hardship hardship. And let me tell you, you can take a lot of different things into account, as you see in our next slide. You can take into account the terms of a collective bargaining agreement, you know, things like those types of things, whether it would violate seniority rights. Negative impact on the morale of other employees is not grounds for an undue hardship. It does need, the undue hardship does need to be significant. I mean, the reality is this: when we get down to nitty gritty asking about undue hardship, almost always it comes down to finances. How much is this going to cost? And if you are going to take the position as an employer, if you go on to the next slide, if you're going to take on the position as an employer that you have an undue hardship that's based upon expense, we're talking serious expense, right? And what are you looking at? You have to look at the your resources, the number of employees you have, the type of operations. You look at the impact of the accommodation on the operation of the facility. You look at your budget. You look at, you know, the bottom line, the more financial resources that you as an employer have, the much less likely it is that you are going to be able to say that the accommodation cannot be performed because it amounts to a financial undue hardship. So undue hardship is very difficult. I can name maybe a handful of cases that I've had over my 30-year career where we really determined that it was an undue hardship because of financial reasons, and it mostly has to do with very small employers. So Covet Accommodations is next. Like we said, we're seeing lots and lots and lots of Covet accommodations, and they're mostly framed in a demand from the employee that the employee is going to tell you what the accommodation is. I'm not coming into work anymore. And as we've seen throughout this presentation and in the case law, you can consider other forms of accommodation that will address the employee's issues other than just granting whatever they ask. You'll see in the next slide that we're starting to do, we're starting to look at cases that are coming through, you know, requests for all kinds of stuff. This King versus Stewart Trumbull Memorial Hospital, the question was the failure to accommodate, and you know, it's always such a fact-specific inquiry about the reasonableness of leave. If you look at the next slide, you know, there's no bright line rule. So these leave issues with ADA come up a lot at the end of FMLA leaves, right, that we've already talked about. And many employers forget that once FMLA ends, you might also have to look at ADA leave if your employee cannot come back at the end of FMLA leave. And again, indefinite leave is probably not reasonable, but I've seen courts say that leaves of up to a year and even sometimes longer are reasonable leaves under the ADA because you just can't, it's so difficult to prove an undue hardship. So take this as the takeaway. When your employee requests a reasonable accommodation, you got a lot of boxes to check and you got a lot of things to look at. And everything is so fact specific that we always recommend that depending on the types of requests for accommodation you're getting, you need to call your legal counsel to walk you through it to make sure that you don't fall into any of the many pitfalls that you can find in this context. So that's the end of our materials today. Thank you again for coming. And I think John is I think we have a few minutes for some questions if there are some.
Yeah, we do. You guys really blasted through it in about an hour, so it's amazing the amount of information you covered. So thanks for that. I do want to open up the questions queue for your questions at this point, if you have any. If you're like me, my head is spinning right now after hearing all that. I did my best to keep up with the pace on the slides. But in our questions queue, feel free to type in any questions at this point. And we certainly understand, you know, if you don't want to ask questions as well. You know, our presenters are available. You're certainly, as Christina just mentioned, you can consult with your own employment attorneys. But now is the time. If you want to ask a question, feel free. I don't see any in the queue at this point. So We'll just give it a minute here. I'm going to cover a couple closing notes, and we will conclude today's program. So last call for questions, if you'd like to ask something. And I still don't see anything. You guys did a great job answering all the questions ahead of time. So kudos to you. Yeah, no, nothing's coming through at this point. So Laura or Christina, any closing thoughts about questions you typically get on any of the material you covered today? Otherwise, I'll proceed to conclude.
I just cannot emphasize enough how fact specific it is. It's really hard. You know, we tried to cover the broad range, but you have to treat every single situation in your workplace as individually. You can't have a blanket rule about how you accommodate people, who you accommodate. You have to, it's a new day every time an employee comes to you requesting accommodation, and it could be the same employee requesting a different accommodation. So be very, very mindful of that, and don't react. The first thing you should do every time is say, could you put your request in writing, and then we'll sit down and talk about this, and walk away. Don't make any yes, no promises. Don't promise refusals in that initial contact. Take time to consult with people within your workplace, with your attorneys, to get your procedure lined up and start it right off the bat from the get-go with a plan on how you're going to address the request. You don't know what the outcome's going to be, but have a plan of the process you're going to follow.
And I'll just
Great.
jump.
We did. Go ahead.
Let me jump in with just one final thought. You know, the last couple of years for all of us in human resources management areas, it's sort of been the Wild West. I mean, for a couple of years, COVID just came out of the blue and nobody knew what to do, and we sort of just made stuff up for a couple of years. That started to come around because the law is starting to catch up. So just be very, very cognizant that, listen, there are new rules, there are new interpretations, there's new everything coming out every day. So what you thought may have been the right thing to do in the middle of COVID may not fly anymore, because courts are starting to take this on. The EEOC is starting to become more involved in issuing more guidance. So the Wild West is sort of drawing to an end, and it's more important than ever that you make sure that you have the most recent guidance before you're making any of these decisions, especially when it has to do with anything COVID related. But thank you all again for coming today.
Before we conclude, we did get a couple of questions, and let me see if I could throw a couple at you real quickly. One is about the history of disability, and the question is, does this mean if someone had back surgery 10 years ago but occasionally has flare-ups of pain, does that fall into a history, or could this be perceived as a current disability?
Could be both, right?
Yeah.
Wait,
yeah.
Laura.
Some of the history cases are people with cancer that are in remission. So they have a history of having had a disability. They don't have it right now. It pops up sometimes with respect to discrimination claims that you don't want to hire a person because they're going to be a drain on your health insurance.
There was a question here about what the FMLA applies to for public employers. You covered this point, but I think it's worth repeating. Can you confirm the FMLA applies to all public employers, even if under 50 staff? And does the FMLA apply to staff as well?
Yes.
Sure. Yep. Go ahead.
Yeah, go ahead, Christina.
Yes, the FMLA applies to public employers no matter how many employees you do or do not have.
But so do the provisions that you only have to give FMLA if you have 50 employees or more within 75 miles. It's the stupidest thing ever.
Yeah.
But so a smaller public employer, yes, you have to have an FMLA policy, but you aren't going to have any employees who qualify to take it if you don't have 50.
Great. And there's a question here. We'll probably conclude on this just because some of them are The remaining questions are very fact specific. There's a question about maintenance techs and whether the question is, maintenance techs require physical capacity when there are restrictions that person can't lift, bend, etc. If the employer determines that they cannot accommodate the restrictions and get the job done, can they be terminated at that time?
Oh, that's fact specific, because there might be a way, you know, I've had those where it's a smaller percentage of the job and a coworker's already been helping them with it. And so that's been going on. Or there might be a machine that could assist with lifting. So it totally depends on the situation. There's never a blanket, okay, to terminate someone without going through the entire process.
Great. And I lied. One last question. What is the public act that protects Michigan employees from retaliation for missing work for COVID reasons?
Oh man, I don't know that site off the top of my head, but if
come on, you don't know all those cases, all those public acts?
I know it. I know it. I know it was passed in 2 segments in December of 2020. But if you Google it, it'll be up there, or shoot us an email and I can give you the site. But it was part of the COVID wave of bills, and employees are very protected from retaliation for COVID reasons.
Great. Thanks for taking a whack at that. There are a couple questions. We'll try to get back to everyone on those after we conclude today. Let me just move ahead and wrap up if you don't mind. We're at our time limit. Just real quick, when you log off, you should be presented with a webinar survey. We hope you will take just a minute or so to complete that. We love getting your feedback. We also like to encourage everybody to share the event page with your colleagues, and even if you want to revisit the discussion here today will be recorded. Hopefully get it up posted later today, if not by tomorrow, but hoping for today. Also, a plug really quickly for our sophisticated employer blog. If you're not familiar, go to our insights page on our homepage, or the insights link on our homepage, and you can find our blogs there. The sophisticated employer blog has a number of years of content that I hope you will check out and share with others. A lot of information about ADA, FMLA there as well. So a quick plug for that. So thank you to our presenters. Great job, ladies. Great to have everybody with us today. We want to thank you, and I will conclude by just wishing you a great rest of your day, and hope to see you down the road at our next event. Thanks for coming.
Thanks, everybody.
Yeah, thank you.